All right, we are back on the record, but out of the hearing of the jury.
Judge, if it's appropriate at this point with the court, I would like to renew the motion for acquittal that I made, or for directed verdict that I made yesterday, and I would submit it without further argument.
All right, and based on the reasoning I gave yesterday, I'm going to again deny that motion for a directed verdict.
And I would also like to, at this time, proffer for the record the 3 exhibits that we sought to have admitted that were
Okay,
denied admission.
that's fine.
Would you show?
I'll just take them up here.
Okay.
Okay, thank you. All right. In terms of jury instructions. Okay. I've reviewed both of your proposed jury instructions that you have submitted. Mr. Matthews, under the case of Commonwealth versus Caudle, which I think we've discussed at least briefly here, I don't see where Mr. Hankison gets a justification instruction, any type of self-protection or protection of other instructions in light of the holding in that case, which relies on the statute we talked about yesterday, 503.120. But I'll let you make your argument.
Judge, I would not argue with you about 503.120, but I would argue that that does not exclude the choice of evils instruction contained in 503.030, which
Okay.
I think is appropriate and should be given.
All right, so would you explain to me the basis of what we've heard and how that would justify that instruction?
Judge, this entire case has been about a police use of force. And I've said at the very beginning, it was not about the death of Breonna Taylor, and yet it was. And I think that the choice of evils, and for that matter, all the self-protection, self-defense justification statutes apply based on the facts of this case, and that is that the police were fired upon. They were justified in returning fire. And I think every one of those statutes that I proposed as potential jury instructions cover that situation. And you haven't mentioned my requested instruction on Graham versus Connor. I don't know if you've considered that or not. But
Well, Graham versus Connor is a 1983 action for excessive force by a police officer, and that was under a Fourth Amendment analysis. I took a look at that case. Whether officers' actions are objectively reasonable in light of facts and circumstances confronting them, very different from what we have here in terms of a criminal prosecution. But I'll let Ms. Whaley address that.
okay.
Anything else you wanted to say?
No, other than I think Graham versus Connor is the standard in police use of force cases, criminal or civil, and I think that's what this case is about. So.
Ms. Whaley?
We would argue that Graham versus Connor is strictly a civil standard under the federal section 1983, which is a completely different standard. We have no liability in a criminal case. As far as choice of evils, the statute itself, 503030, section 2, first of all, that defense is applicable when the defendant intentionally to avoid imminent public or private injury greater than that injury sought to be prevented by the statute. But Section 2, even in choice of evils, is when the defendant believes the conduct which would otherwise constitute an offense is necessary for the purpose described in subsection 1, but is wanton or reckless in having such belief, or when that is wanton or reckless in bringing about a situation requiring the conduct, then that justification is unavailable. It's similar to 503.120, section 2, subsection. D. So allowing a defendant to have a defense under choice of evils would actually arguably be inconsistent with the language of 503.120, subsection 2. Due to the purpose of, it's 503.120, subsection 2 is completely on point here. As noted by Commonwealth versus Cottle. So we would argue that defense is not available, nor any other justification defenses.
Well, 503.030 begins with, unless inconsistent with the ensuing sections of this code defining justifiable use of physical force, or with some other provisions of law. And, I mean, I think we're talking about 503.120. So I think this is inconsistent with 503.120. And therefore not available. I'll read a little bit more on this before I make my final decision. All right. Mr. Matthews, did you have any problems with how Ms. Whaley wrote the instructions? I know that you disagree with what's been left out, but with what is in place, do you agree with that?
As I recall, Judge, I had no difficulty with what's in place. I think there's just
Okay.
3 guilties and 3 not guilties, if I recall, plus a few standardized kind of instructions.
All right.
In our proposed instructions, the only one that would need to be removed is instruction 2A, the right to remain silent.
Right. We'll take that out. just trying to think if this is say, look under instruction number 4, pertaining to Cody Etherton, the wanton endangerment first degree, paragraph A, that in this, or subsection A, that in this county on or about March 13th, 2020, and before the finding of the indictment herein, he, meaning Mr. Hankison, shot a gun into a dwelling. B, that he thereby wantonly created a substantial danger of death or serious physical injury to Cody Etherton. What I'm wondering is if there needs to be a little bit more elaboration in that shot a gun into apartment 4, or shot a bullet into apartment 4, which bullet went then into apartment 3, thereby wantonly creating a substantial danger of death or serious physical injury to Cody Etherton. I don't know exactly how to phrase that, if you all have suggestions on that, but I think it needs to be a little bit more than what this says to accurately represent, because I don't think there's any dispute about the facts. The facts are what the facts are. No one has disagreed that that's what happened. No one's saying Mr. Hankison shot directly into apartment 3, and no one's disputing that he in fact shot into apartment 4. So I think the wording needs to be cleaned up just a little bit for the jury so that there's no confusion about this. So if you have a proposal on, and that would be the same for all 3 instructions, obviously, for each of the 3, for Mr. Etherton, Ms. Napper, and the child. If you all have suggestions, I'm happy to hear those. Or if you want to think about it and email it to me later on, that's fine as well. Other than that, I think the instructions, unless I change my mind on the choice of evils, are going to be pretty straightforward and simple. All right, anything else regarding instructions?
No, Your Honor.
Okay, well, I'll work on those and email you all the final version later today. In terms of closing argument tomorrow, Mr. Matthews, can you give me a ballpark? Although I asked you to ballpark your direct, and
That was a little
so
long.
now I know I need to double whatever you tell me.
Well, I was going to say, how about 5 minutes up to maybe 5 days? I don't know.
Would an hour be
I
sufficient?
think an hour would be.
Ms. Whaley?
Yes.
Okay, I think an hour should be plenty. I mean, I do feel like our jury has been very, very attentive, and I can't imagine they don't have a good grasp on the facts, so I think an hour would be fine. All right then, I will see you all tomorrow, maybe around 9:15, just to make sure the instructions are clean and good, and so that we can be ready to get started at 9:30. Okay?
Thank you, Kelly.
Thank you.
Thank you.